Let's flip now before we let Mr. Ikeji go to talk about the development that played out in the House of Representatives yesterday, and you may see the images soon. Mr. Ikeji,
yes.
Honorable Abdulmumin Jibrin suspended for, I think they say, 180 sitting days,
yes.
And then he will not hold any position in that for this 8th Assembly.
Yes.
And then he said, look, this is errant, can't stand. That's contempt of court. He's instructed his lawyers to go to court. What do you think of this?
Well, as far as the matter is in court, there is a limit to which we can contribute. But we can speak about the issue peripherally. And speaking about the issue peripherally, since the matter is in court, ordinarily one would have expected the House to have tarried. However, the Legislative House's Privileges and Powers Act clearly empowers the House to do what it is doing presently. Clearly empowers the House.
In what way?
Because one of the provisions of the Legislative Houses Act says that no civil or criminal proceedings shall be instituted against any member of the legislature for anything done that is qualified privilege. Furthermore, it also goes ahead to empower the House to suspend, without reference to any court of law, to suspend a member who publishes anything that has been brought in evidence before a committee. Or again, it goes also further to also provide for punishment, in fact, criminal punishment for any member who publishes anything that impugns on the integrity of either the President of the Senate or the Speaker of the House.
Even if it's a fact?
Even if it's the fact. Once it impugns the integrity by the judgment of the House this time around. Now, Section 6 of the 1999 Constitution, as amended, clearly empowers the courts to enter into any matter between any person, any individual, any government or authority. Based on that, yes, Jibrin may approach the court. But I doubt whether that power is to be exercised in such a way as to influence or derail what is happening inside of the House of Representatives. And this is where I think Jibrin may be shooting himself on the foot.
Can the case of, we saw Dino Melaya and some others in the House at the time when Dimeji Bankole was Speaker, also suspended. Can that serve as some sort of precedent in this matter?
To an extent, in that case, you remember that Bankole was invited by EFCC. He was investigated. He was even taken charged to court. But nothing, of course, we found out that nothing came out of it. That is a different thing altogether. Dimeji Bankole, in that situation, had issues with corruption that borders on crime, that had crime underlining them under our criminal laws. But the one of Dogarad now, there's no clear law that has stated.
No, but you said the House, even if it's a fact, if it impugns the integrity of the House, you said they can proceed according to the...
Yes, even if it's a fact. For example, the fact that the Speaker purportedly added more constituency projects to his own budget before the President signed it, to me, does not equate to a crime. So even if you have said, even if it is true, we are not saying it is true. Of course, we know what goes on in the House. So even if it is true that the Speaker has had some kind of preferential treatment in allocation of constituency projects, Jibrin was running foul of the law in bringing that process, that issue, out to the public under the Legislative Houses and Legislative Houses Privileges and Powers Act. It is there in the law.
Okay, Mark can hear us now. Mark.
Oh yes, I can. I was just a little curious. I mean, are you referring to the rule book, or are you talking about a law that the National Assembly members made to protect the National Assembly? Is it the rule?
No. You are debasing it by saying the National Assembly members made to protect the National Assembly. It's a law made by the National Assembly, and not this National Assembly. It's not even the rules of the House. It's a law. Legislative Houses, Privileges and Powers Act. Look through Section 21, Section 22, Section 23, Section 24, Section 31, Section 32, Section 33, Section 34. You will see details of the events that are occurring presently in the House.
So in this case,
you say that, you know, we're debating it by saying that, you know, they made it to protect themselves, but,
yes.
But isn't that what it is? Because if something were true, it cannot be published about the Speaker or the Senate President, you know. Isn't that a problem?
No, it's not a problem. It's not as if it is secret. It is saying that any evidence that is given in a committee sitting in the House shall not be published. You have to get the approval of the relevant authorities to publish it. It's a legislative committee matter. It is not for public consumption. And I'm not saying that it is transparent. It is normal qualified privilege that every house all over the world, it's a common law principle of law. Even before Nigeria started as a country, it existed as a law. In England, we have it as a law in England that what happens in the legislative houses has a qualified privilege, such that there is a limit to which you can interfere in the events there.
You know, what happens to the constituents now
yes.
when your representative is suspended for that number of days? It looks like till this legislative tenure is over, you don't have a representative.
Yes, I think that is the reason why there has to be a political solution. We know that what is happening in the House is anything but good. We know that there are a lot of tendencies in the House that are not good. So the way I think that can best solve the problem is for Jibrin and Dogara to ensure and use political means to resolve the problem. Going to court, in my view, I will not preempt the court, but in my view, the court has power to investigate, to ask questions of any person of any authority, including the Speaker. However, you will ask the question, if the law also provides for this qualified privilege, to what extent would the court go in interfering in that qualified privilege? For example, in impeaching a Speaker or impeaching a governor, there's a process that has been listed, that was listed in the Constitution. If you follow that process, the court cannot question your power to impeach. But it is when you don't follow the process. So the question that the court can come in here is whether the process of suspending Jibrin was legal.
What about those who then say, what happens to the principle of natural justice? Because this may appear as though the lawmakers are being judges in their own case.
Yes, thank you so much for that question. The principle of natural justice has two arms: audi autarem patem and nemo judex in causa sua. Audi autarem patem says, hear the other party. Yeah. Nemo judex in causa sua says, you cannot be a judge in your own case. In this instance, there is evidence, as far as what is available in the public is concerned, that Jibrin was invited. But he informed the committee. He said the committee is already biased against him, and therefore he cannot appear before the committee. That is a sufficient application of the principle of audi autarem patem.
Well, all right. We'll just have to let this go at this point, even though there are other areas you have explored.
Yes.
I'd like to thank you for coming on this morning.
Thank you so much.
Ikechukwu, Ikeji, a legal practitioner.